Okay, so today we're going to continue with looking at the principles of the Individuals with Disabilities Education Act a bit more closely. So last time we looked at a couple of the principles, and this time around we're going to continue with principle number 4, least restrictive environment. And we all certainly have heard about LRE, but what does that mean specifically? Well, it means to the maximum extent appropriate, children with disabilities are educated with children who are not disabled, and that's actually what the law says. And we do know that right on our IEP there is a space for justification in terms of amount of time in general ed and amount of time out of general education, and our rationale for that. And so removal of the child with disabilities may only occur when education in the regular class setting with the use of those supplementary aids and services cannot be achieved. And that's important because we've had court cases and actually a very large class action settlement in our home state, Pennsylvania, that really looked at the fact as to why children with disabilities were not included more often than in other states, and that was referred to as the Gaskin settlement. And they looked at the lack of supplementary aids and services placed with the child in an education setting that was less restrictive in the gen ed setting, and essentially found that we needed to do more of that and it needed to be appropriate. So we know that LRE means there is still this continuum of placements. We have not gotten rid of those. We do have placements, and the placement has to be appropriate for the child. We cannot confuse placement with program, so that if the child's IEP can be implemented successfully in any of these settings, and that's the appropriate setting to do so, that's what we need to consider. So the theme is certainly one of appropriateness for LRE, and we know that we're still looking at the individual child, that not all placements fit all children, and that we offer a continuum of placements. They must be available. And there is this bias towards the general ed setting and towards including the child with non-disabled children. So when we are considering placement, we need to make sure that that the placement is helps the child with the child's particular disability, that we don't want to to rephrase it differently, we don't want to place a child in a classroom, for example, in an autistic support classroom, even if the child has autism. That might not be the appropriate placement, so that the title of the type of class doesn't necessarily go along with the disability category. So we may not be providing services where they're traditionally provided. And we certainly, again, along the lines with children who exhibit behaviors that that does not necessarily mean the most restrictive environment if the child has an appropriate behavior plan that can be implemented in a less restrictive environment, and we cannot consider cost as a factor. So how do we determine then least restrictive environment? Well, we make sure that that the appropriate education is being offered in the plan, and that we look as to whether or not that plan can be implemented in first the general ed setting, or at least, if not full-time, at least part-time, with supplementary aids and services. And if the team says no, then only then will we look at an alternative environment. The next important principle built into the law is procedural safeguards. And this is, there's a number of things we do to protect the child and the family, and the district as well. We need to make sure that the procedural safeguard notice is sent out, and that consent for evaluations, meetings, etc. is done appropriately. We need to make sure that we know who the parents are, who is involved. Are there surrogate parents? Is there a divorce situation where there's two partners involved? Are there extended family members who are the parents? We need to make sure that all parties have an opportunity to examine the child's records and also to protect those records. We need to make sure that parents know they have a right to an independent educational evaluation at public expense if in fact the evaluation by the local education agency is not appropriate. There are discipline provisions built into procedural safeguards, particularly the fact that we cannot exclude children with behavioral challenges from a free and appropriate public education, and also if there is a certain type of behavior exhibited, that the child goes through the appropriate process of manifestation determination and functional behavioral assessment. We need to make sure that families know there's a range of conflict resolution processes available to them before a due process hearing, such as mediation, and in our home state in Pennsylvania, offered through the Office for Dispute Resolution, such things as IEP facilitation, mediation, and some other services for parents and families. And that there is built into the last reauthorization of IDEA a resolution session before we go to due process, and this resolution session has to occur unless it is waived by both parties. And finally, if we have to go to due process, that the hearing officer is an impartial judge, so to say, that is hearing the case. So the procedural safeguard notice is quite lengthy. You can see an example of that if you haven't already, from our website, the Patan website, or the Office for Dispute Resolution website. And your textbook has examples of procedural and safeguard notices as well in it. But a procedural safeguard notice may be given only once a year. It used to be given at every meeting, but it has to be given at initial referrals, parental requests for evaluation, initial filing of a due process, and at the request of the parent. School districts may post procedural safeguard notices on their websites, and that's helpful. And the procedural safeguard notice must include time frames for filing due process, the opportunity to resolve any issues, information on mediation, time frames for lawsuits. So what is mediation? Well, states do have to offer mediation, but it is voluntary. And it's voluntary, but it's less formal than a hearing, and it is to resolve disputes, and the mediator, again, is unbiased. The mediator is simply there to mediate the session or sessions. The mediator has to be trained and knowledgeable about special ed law and has to be impartial. And if mediation is unsuccessful, again, it is voluntary. Either party, either the district or the parent, may request a due process hearing to resolve the issue. But at the mediation, hopefully it's successful, and there's a written settlement agreement. And so if resolution is reached to resolve the issue or issues, then it's signed, this agreement is signed by both parties, and it is enforceable. If parties execute a written settlement agreement, a party may void the agreement within 3 business days. Now, if other forms of conflict resolution do not work, then either party may go to due process. So either party may initiate a hearing. And hearings are, come to be due to a number of reasons, but they can be, there could be complaints around identification issues of the child, evaluation issues, placement issues, also appropriateness of the plan. And the hearing must be conducted by the local education agency by a hearing officer which is trained and is impartial. And the parents cannot go, the law says the parents cannot go directly to court. They must follow these administrative remedies before they can do any appeal and go into a court of law. However, if they disagree with the hearing officer's decision, they then can move on to a court. So there are definitely procedures for a hearing, and there's procedures for related to timeline as to the hearing has to be completed in a timely fashion. But again, the parents have the right to file in terms of any disagreement. The party that has requested the hearing cannot raise issues that have not been identified up front. So in other words, they can't request a hearing for, let's say, evaluation reasons, and then get to the hearing and say, well, there's some other issues we want to discuss too. And there are important reasons for that. Both parties, because a hearing is like a court of law, there's testimony given and there's evidence looked at. And both parties, their attorneys, because there are attorneys involved at this point, need to be able to prepare to question witnesses and prepare with looking at the documents and formulating their questions for their case. The law does indicate that there is a 2-year limitation for filing due process unless there are some alleged violations, such as there was purposeful reason for keeping information from the families. So there are some loopholes in that, but essentially the law says we can't go back 3, 4, 5, 6 years in our complaints. So again, time limits may not apply if the parent can show there were specific misrepresentations and there was withholding of information. So again, either party can request the hearing, and they must do so within 15 days. They have to request, and it has to be a sufficient request. There has to be enough information on this request. And so there is a hearing officer assigned, and the hearing officer will receive that request after the state agency provides it to the hearing officer. So in terms of this particular slide, it's really just the timeline in terms of the hearing officer receiving the request and then responding within a time frame to the parties and letting them know that the request was either sufficient or insufficient, meaning that the issues are understood. And if they are insufficient, then there's also a timeline built in for either party to respond. Within 15 days of this notice, the local education agency must convene what's called a resolution session. Now, at this point, parents and districts have gone through a lot, and they may or may not want to go to resolution. They might want to go right to due process. So either party may agree in writing to waive such a meeting, to use mediation if they want, or maybe that's already been tried, but essentially this meeting has to be scheduled. So again, at any stage of the process, there could be a settlement agreement. So even if there's been a filing for due process, at a resolution meeting, there could be a settlement agreement. But the hearing officer is, if it does go to hearing, the hearing officer will determine if there were any procedural violations. So in other words, was the special education process violated? And did it rise to the level where FAPE was denied? So there could have been, some slight procedural violations, but maybe it didn't really rise to the level where the child was denied FAPE, such as maybe a couple days past the evaluation process timeline. Um, so, did what occur impede the child's right to FAPE? Did it impede the parent's right to participation in the special education process? Did it cause a loss of educational services, is what a hearing officer may determine. Again, there is a whole lot built into this process, but we can't be filing what's called frivolous suits, unreasonable suits, suits without foundation. Um, so that's determined up front, or usually, but again, if there's an appeal, the same thing applies. And so these particular slides deal with some things we're not going to really worry about as future teachers, but attorneys' fees in a hearing process is quite important to the attorneys involved. So that is spoken about a lot in terms of the regulations. And we talked about mediation. It cannot, I guess the important point on this slide is it cannot be used as evidence. So, once a mediation settlement agreement is there, it is enforceable, but it cannot be then used as evidence. So we're going to move on now to some discipline provisions, and we're going to come back to that later on in more in depth. But there are procedural safeguards for children in terms of discipline as well. And we know that for a child that exhibits a behavior, there is a process referred to as manifestation determination. And simply what that means is the behavior that the child exhibited a manifestation of his or her disability? And so again, every part of the law, if you haven't noticed, you're noticing now, has very strict timelines in terms of when we have to do something, how long it should take us to do something. And so the manifestation determination within 10 school days of the decision to change the child's placement, because that actually may be occurring, a manifestation determination meeting and process kicks in when in fact we are looking to or have placed a child in a interim alternative educational setting, or IAES. And so, team members are involved in making this decision and conducting a functional behavior assessment. And children will be removed to an IES for 45 days, at which time the whole process of manifestation determination has to take place for any weapons and drug offenses or serious bodily injury upon another person. And serious bodily injury is also defined in the law, so it has to be substantial, there has to be a risk of death as a result, there has to have been extreme physical pain as a result, any disfigurement, and or loss of impairment. So what are some protections for the child? So if the local education suspected or knew that the child had a disability that involved a serious behavior, if the parent expressed concern, if the parent requested an evaluation, if professionals of the LAEA expressed concerns, and if they were not taken care of, in other words, we did not offer the child a sound behavior intervention plan, then technically the school district, the LAEA, is at fault, and that even though we need to remove the child, then the child could potentially go back to that original placement with a sound behavior intervention plan in place. Again, we'll skip over attorney's fees, but they are important in the law, and move on to Principle 6, parental participation. So we know that parents are an important member of the team written directly into the law, and that we have to be providing notification, and we have to be receiving written consent um, at various times throughout the special education process, and for them to participate in educational decisions. So when must this consent be obtained? Well, before beginning or changing a student's identification, conducting a pre-placement evaluation, initial placement or change of placement, and conducting a reevaluation. Consent is voluntary by the parent and can be revoked at any time. In terms of having parents participate in any of the meetings related to their child, school districts must provide notice, of course, ensuring that the parents have the opportunity to address and participate in meetings that certainly address evaluations and program and placement. And that concludes our third part on principles.